So I'm going to be talking to Joanna today about the biggest change in divorce law since 1973. Joanna, what is this change and what does it mean?
Well, Kirsty, we now finally, after many years of campaigning, have a no-fault divorce system with effect from the 6th of April. And what that means is that all applications for divorce will be based on the irretrievable breakdown of the marriage, but it won't be necessary, as it is at the moment, to rely upon adultery or unreasonable behaviour of your partner or a minimum period of separation.
And how will it work in practice? Is it the same as it is now with one person starting the process, or will they do it together? What's changing there?
So both will be possible in the future. One person can apply for the divorce on their own, or they can do it on a joint basis, which is a change from the current system.
And what happens if one person doesn't want a divorce? Can they end up being divorced without agreeing to it?
Effectively, yes. There won't be any basis for opposing a divorce on the basis you don't agree that the marriage has irretrievably broken down. There will be one or two exceptional cases where, for other reasons, you can oppose the divorce, but you won't be able to say you don't agree that the marriage hasn't broken down irretrievably.
That's going to be a shock for people who are religiously opposed to a divorce to find that even though they've given their marriage vows and seriously intended to be married for life, against their wishes, the other spouse can just end it.
It will be, and there will be some categories of people that won't like the no-fault divorce system. But for the vast majority of couples, it takes away one layer of unpleasantness and acrimony in that they don't have to cite reasons for applying for the divorce, and they can instead focus their energies on agreeing the arrangements for any children and the longer-term financial arrangements.
And how long will this process take? Because some people say it's actually going to take longer than the current process, which sounds like a backward step.
So it will now be a minimum of 20 weeks between applying for your divorce and the first formal stage, the conditional order, and it will then be 6 weeks and a day between the conditional order being obtained and you being able to apply for your final order, which we currently call the decree absolute.
And you say conditional order, but it's not actually conditional on anything. There's nothing that's going to happen in that 6-week gap that you have to do to get your final order, is there?
No, it's a final cooling off period before you can apply for that final piece of paper, which is the document which will formally dissolve the marriage. But no, there are no conditions as such.
And again, I think a lot of people assume that they will have the opportunity to file something setting out the arrangements for the children or setting out what they've agreed financially, and that would have been the obvious time to do it, wouldn't it, in that 6-week gap?
Yes, and that's not happening. So we're going to carry on with the system that we've got at the moment, where you have potentially 3 strands when you separate, and those strands can be concurrent, but they're not conditional upon finishing one before you can do the other. So in addition to the divorce itself, you need to sort out the arrangements for any children and the longer term financial arrangements between the two of you.
And what happens in a situation where people have been unable to resolve their financial issues? They can just potentially take many years to do that, as they can now. Is that still the case?
Yes, the system with regard to financial applications is exactly the same. It's not changing. It's only the divorce itself which is changing.
So there we have it, the biggest change to divorce law for decades.
Absolutely. If anyone has any queries or questions, then please do contact Kirsty, myself, or any of the other members of our team.